This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about how a court system can be abused by an Forma Paupers plaintiff, that is, a plaintiff without enough funds to file filing fees to file a lawsuit, and why a court will allow a pro se plaintiff to continue to abuse defendants by refusing even to pay policy limits to the plaintiff, which she alleged was fraud, is simply not fraud. No right exists to sue in federal court after losing in state court by suing the exact same claims. The case began when plaintiff Sonia C. Roberson in pro se was granted leave to proceed in Forma Paupers without paying any filing fees. Her first attempt was dismissed by the court, and the defendants were still required to pay filing fees and their attorney's fees to respond a second time. The second time, in Sonia C. Roberson versus Rex Miller et al., the United States District Court for the District of Oregon on September 24, 2024, dealt with the amended claim and suit with charity and patience to the pro se plaintiff. The defendants, of course, filed a motion to dismiss, and to survive such a motion under the federal pleading standards, the complaint must include a short and plain statement of the claim and contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face. However, a pro se pleading are held to less stringent standards than pleadings by attorneys. The pro se litigant is entitled to notice of the deficiencies in the complaint and the opportunity to amend, unless the complaint's deficiencies cannot be cured by amendment. In her amended complaint, the second try, plaintiff seeks to bring claims against Rex Miller and the others, including Farmers Insurance, for multiple charges from insurance fraud to seeking criminal prosecution in a federal district court, as if she were a prosecutor. Plaintiff's amended complaint took up 89 pages, mostly handwritten. The narrative presented was disjointed, repetitive, and the court admitted difficult to follow. Plaintiff alleged that she was injured in a fall on the stairs to the residential unit, and that she sued Rex Miller in Coos County Circuit Court for her injuries. Plaintiff was unsuccessful in that case, as she filed an unsuccessful appeal with the Oregon Court of Appeals and tried her luck after that failure in federal court. Plaintiff, in a telling admission that should have kept her from being allowed as a pro se plaintiff, when she alleges that she suffers from schizophrenia and that she is scared of Defendant Rex Miller spying on me under the stairs and other injuries, etc., close quote, and 3 exclamation points. Farmers insured Millers and Agritech for the property where plaintiff lived. Plaintiff alleged she was offered $60,000 to settle the case on the eve of trial. Defendants also appear to have offered plaintiff up to $100,000 to settle her claims that were not accepted. And after the trial, the jury returned a quick judgment in favor of the defendants. plaintiff giving evidence of her claim of schizophrenia, alleged that Rex Miller, quote, started criminal illegal acts, and I believe he is illegally using his favoritism to spread discrimination, plague disease of his illegal retaliation and jealousy, close quote. The court empathetically explained the principle of preclusion because throughout the amended complaint there are repeated references to Rex Miller's testimony during a civil trial, apparently concerning the injuries plaintiff sustained while she was a tenant of the Millers' property. Preclusion, the court explained, is a legal rule that a plaintiff who has prosecuted one action against a defendant through to a final judgment is barred from prosecuting another action against the same defendant where the claim is the second action is one which is based on the same factual transaction that was issued in the first, and seeks a remedy additional or alternative to the one sought earlier, and is of such a nature as could have been joined in the first action. Here the amended complaint makes it clear that plaintiff's injuries arising from her time as a tenant of the Millers were fully litigated in a jury trial in the Coos County Circuit Court in Oregon, and that the jury returned a verdict in favor of the defendant. The United States District Court, of course, as a court of original jurisdiction, has no authority to review the final determination of a state court in a judicial proceeding. Plaintiff also appeared to allege in her claim for fraud that the defendants offered to settle plaintiff's claims in the state court lawsuit for $60,000 to $100,000 rather than the policy limit of $2 million. On its face, that is not fraud. Plaintiff is a private citizen and does not have standing to initiate criminal prosecutions of another person, as her amended complaint attempted. The court, with the patience of Job, had previously afforded plaintiff leave to amend her complaint, and in consideration of plaintiff's status as a self-represented party, the court, as an expression of empathy, provided her one more opportunity to amend her complaint and warned her of repetition on the findings of the opinion. The defendants must therefore, on her third try, again pay to defend that third try to state a cause of action, and will incur enormous attorney's fees, since they'll probably get another very long handwritten judgment or complaint to answer. The amended complaint was dismissed, therefore, with leave to amend, showing the judge in this case had absolutely more patience than any lawyer should ever have. In my opinion, litigation is a privilege, but it is not a privilege without limits. The plaintiff, by continuing to sue the defendants, with the court allowing her to file a third complaint after losing in a state court jury trial and suing the same defendants in federal court, gets her a win by forcing the defendants to pay to defend this spurious action. The schizophrenic, in a complaint filed as a pauper, has absolutely no expense but her time, and by filing an almost 90-page handwritten complaint that was almost impossible for the court to decipher, resulted in a dismissal, but with leave to amend, leaving the defendants with excessive costs and expenses trying to understand her meandering through legal principles only to obtain a Pyrrhic victory, so they can go through the exercise once again. This, in my opinion, is an abuse of the legal system, giving an allegedly poor person more rights than the defendants. To paraphrase George Orwell in Animal Farm, all litigants are equal, but it seems some are more equal than others. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,900 blog postings. You can also subscribe for free to these videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the thumbs up button on rumble.com and the like button on youtube.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Please tell your friends and colleagues about this blog and the videos, and let them also subscribe to the free blog and the free videos. Thank you for your attention.